Cool. All right, I think we can get started. Don't want to make you guys wait any longer. Just some housekeeping before we start. We will be recording this session. This is considered processing in terms of POPI, which all of you should know about. If you don't, we're here for that. If you don't want your information recorded, simply turn off your camera and remove your name. Cool. All right. So let's get started. Can I just give us a little introduction? Some of you may know us. Some of you know us very well because we've been providing you with legal services. Others may be new to us. So let me give you just a little introduction about who we are. Legalese is a creative legal agency which has redesigned the way in which legal services are provided. We try and create tailor-made solutions where we're not necessarily just fixing problems, but we're actually preventing them from occurring. We do this in a manner that is accessible, affordable, and understandable. We pride ourselves in being able to assist in the startup and entrepreneur space and being relatively tech savvy ourselves and having quite tech savvy clients that we service. We're not a law firm in the traditional sense, so you definitely don't want to come to us for arrests or drunk driving. That's not what we do. We focus on your business and your vision, and we try and assist you in all facets that have to do with getting you to that successful space you're seeking. A little bit about me. I am an American, as you can probably hear from my accent. I've been living in South Africa for 11 years, did my postgrad at UCT, been practicing and living in Cape Town for quite a while now, and have joined the Legalese family this year. And I'm a commercial associate primarily with our contracts, but also we do quite a bit of dispute resolution and assist in that regard as well. As you can see, Legalese prides itself on being a part of a community. We try to keep ourselves as personal and engaged with our clients and with the spaces that are relevant to them and to the work that we do. We try to also be very cognizant of our impact on our communities and the spaces around us, and love to participate in collaborative efforts with our clients in those regards. So why are we here today? Today, we're talking about digital live streaming, specifically how to protect your rights and your intellectual property. Let me tell you a little bit about what we're going to cover, just so you can kind of get an idea of where we're going and what the intention is here. I'm going to start off kind of giving you a little basics on the statistics. As you can probably assume, the past year has been an increase with regards to digital live streaming. But also, why stream? Like, why are we doing this? Why is it important? Then a better understanding of the variety of rights involved. Variety of purposes also behind these live streams. Then we're going to go through some of the popular platforms. We're going to look at their terms. I'm not going to go into the detailed nitty-gritty of each of these terms, but I want to show you where to look. And I want to show you how to find what's important in these very big terms of service. Then we're going to discuss the protections that you get, but not just the protections you get here in South Africa, but also mention some of the protections you get overseas. Then we're going to look at the consequences of infringement, right? So if you yourself are infringing, what happens? And also, if someone's infringing on your rights, how do you fix that? We're going to look for those solutions and then hopefully have some time built in so that you can ask me some questions. But if we don't, you can always shoot us an email. I'm very happy to communicate with you guys that way. Cool. What are the statistics? Well, like I said, you could probably assume there has been a lot of growth in the past year. People watch videos on their desktop for an average of 7 minutes a day. They watch videos on their mobile on average 16 minutes a day. Now, I hate to break it to you, spoiler, I'm gonna hold you here, hopefully, for longer than 16 minutes, or at least hopefully you're gonna stick with me for longer than that. In 2020, 232 million people watched streaming across all devices in the United States. That number is set to increase this year. In the past year, daily watch time for Facebook Live broadcasts have increased 4 times since 2019. User-generated content accounts for 51% of live video content streamed on mobile devices. You can see businesses are streaming and broadcasting live videos once a week. 53% of them have admitted to that. 54% of consumers want to see more videos from their brands they support. Now, I hate to break it to you, but blogs are not enough. Articles are not enough. Neither are those campaign ads. We need to be engaging, and people want that. They're seeking some type of engagement from the brands they want to support. Video streaming market is predicted to be worth $124.6 billion by 2025. I mean, that seems about right to me. Now, what's the point? Now, those statistics obviously have implications, right? They give you access to more people. Well, then why do we stream? Why are we thinking about streaming? Well, it gives us connection. Despite this global pandemic, we can connect to audiences that we couldn't otherwise. Also, it gives you an opportunity to increase the people with which you connect. It isn't just the people in your immediate surrounding. It isn't just the people you've previously worked with. It's also people overseas. It's also people in different cities. It's increasing your user engagement, not just with your content, but also with your business and with your brand. Now, this has been an upward scale since 2019 from those statistics, right? It's likely to continue increasing in 2021, and I'm sure we'll see another increase in 2022. This trend is not really a trend. It's definitely here to stay. And also, I love this picture because it just reminds us that sometimes it's about that engagement and it's about being liked and liking other people's content and sharing in that community. But what's really important is how we understand the rights involved in this content, right? It isn't just about putting whatever you want out there. It's who owns which rights. And that question is much more complicated than it may seem. The thing is, rights are bundled together. There's not just a single right that results from ownership. There's a bundle of them. For example, right, the right to an image can change in specific jurisdictions based off different frameworks. We had a client who is German, and they were coming to South Africa. And one of the things that we had to kind of walk them through was the difference between the subject owning the image and the photographer. Now in South Africa, if you commission a photographer, the person commissioning is the owner. Whereas in America, the person who clicks that button, whether they own the phone that clicked it and took that photo, or they own the camera, it's the person who actively clicks it and takes the photo that owns it. So you can see how this can get so complicated. And it's really important to follow some tips. Identify who those creators are. Is there any license that currently exists for that content? If it exists, to what extent does it exist? On which basis does it exist? Certain things can be licensed for non-commercial use only, and therefore have a limited ability to be used. Other things have unlimited licensing And unlimited, I say in quotations, because it's never really entirely unlimited, right? It's important to see how these brand affiliations happen and whether or not they're officially supported by the brands themselves, or if, for instance, they're not sponsored, but they are associated. It's important for you to accurately attribute these authors. You can't just go and give out content that isn't yours and not at all say who they came from. Original content is key, right? But it's not always going to be the case. You're not always going to create original content. And the concept of originality is also in and of itself a complex and gray area in law that has various points of movement in it. So just to give you an idea of some real life examples of where these complications come into play. I'm not going to lecture on these entire cases. You don't have to know the ins and outs of everything that was involved in them, but I think it's quite interesting for us to just kind of reflect on previous cases and see how the law develops. Now, I don't know how much of you are Apple fans or Microsoft fans. I know that in our office we have debates. But this case in particular was quite an interesting one, insofar that Apple tried really hard to control their graphic user interface and trying to say that this idea was theirs. And what ended up happening is after 6 years long of litigation and lots of money spent, Microsoft ended up winning, and the concept of ideas versus the manifestation of ideas was solidified in our copyright law. Now, this happened in the American jurisdiction, but these have effects in the way in which we understand how these rights flow. Another really interesting example, but maybe also not memorable for everybody, is Napster. How many of you remember Napster? A&M Records came after Napster because they were sharing IP that they themselves had licensed to. They ended up, as you probably know or remember, taking Napster down by hitting them with a huge fine, and Napster having to give an apology and shut down its services. And a more recent one is the Blurred Lines case with the Marvin Gaye estate and Robin Thicke and Pharrell Williams. Now, this one is very interesting and quite strange because what it ends up doing is extending the protections of copyright as we know it. What happened was with Robin Thicke and Pharrell Williams, they admitted to being inspired by Marvin Gaye in their song Blurred Lines. And the Marvin Gaye estate pursued them and won. And a new concept of protecting the style of music, so not just the sampling of music, not just the lyrics, but the style had been established in law. And this is just a perfect example of how the law is ever changing and nowhere near black and white as many people wish it to be. So what are the different types, different formats, different purposes behind these live streams? I want to just focus on panels, webinars, and your traditional streamers. Now, I had the absolute pleasure of participating in a panel earlier this year, and we were able to focus on Africa Day, and our topic was digitalizing Africa for entrepreneurs in the African continent seeking to expand their digital footprint. Now, one of the things that I love about this particular format is the collaborative engagement, right? I was the legal voice on this panel, but it was so interesting to hear the other panelists speak about their businesses and their business experiences and share tips for other entrepreneurs trying to expand their footprint online. What's really beneficial about this type of format is there's a clear legal framework to ensure that infringement doesn't occur, right? We all had to sign release forms. The presenter also had to sign release forms. Any music that was used had to be licensed. Videos that were used had to be licensed. And the images themselves either had to be rights that they were currently holding or purchased. Webinars, which all of you are attending right now with me, are another great format for you to engage with your customers, new customers, and audiences, and also to avoid infringement. These webinars can be educational. They can also be musical. I mean, if you think of TED Radio, I don't know how many of you listen or watch TED videos, but I'm obsessed with them. And they can be educational, like we are today, discussing a specific topic and sharing that information with each other. Or they could be performances. They could be people sharing their new inventions. And what that ends up doing is it assists in building a brand. Now, specifically with TED, their brand is very well known, right? We all can see that TED logo in our head. And with legalese, the So Now You Know webinar series has been a part of our brand for this year, something that we've tried to do to engage with you and also share our knowledge with each other. What is the legal framework here? Well, you have to make sure that the images you use are rights that you hold or public images. You have to ensure that any of those videos you use have license, similar to the panel format. You're also going to need to ensure that that music that you're putting into your webinar is also licensed. My director and I were discussing what is a really great way in which we can protect your webinar. And his suggestion was watermarking. And I think that's genius. Our ops manager, he creates these training videos for us and he ensures that they're watermarked. And that's something that you could definitely do to protect your series that you have. As you can see here, we have the Legalese logo just behind me. Now, what about the traditional streamers? Now, this is probably the first thing you think of. You don't necessarily go to the panelists in your head. You don't necessarily go to the webinar series in your head, but maybe you do now since COVID has happened and more of them are happening. More people are attending them. But the traditional streamer on the very popular platforms is the one that everyone thinks of. And this is definitely by far the most popular format of digital live streaming. And what's great about these is the symbiotic relationship between the creator, the platform, and the ad revenue. A lot of these are entertainment specific, right? But they can also be educational and informative. What is the legal framework here? Well, we're going to go into the specifics with regards to these popular platforms, but as a rule of thumb, on any platform, not just the three that we will be discussing, you have to look at the terms of service or the terms of use. Specifically, you need to look at how they're licensing the content. Because as you'll see when we go into these three platforms, that's the structure with which they deal with your content. Now, there's some really interesting legal concepts that get played here. Parodies, critiques, and reactions. Now, if you think about some of the videos you probably watched either earlier today or sometime this week, they may have either been parodies, and I can think of quite a few song parodies that I've heard over the past year that very creative people have put out there. I can think of critiques, where people have the video playing as they critiqued and as they also react. The reaction videos spark emotion in the viewers and get a lot of view counts. And the platforms love that because it increases their ad revenue, right? So what are the three platforms that I want to focus on with you today? It's YouTube, Twitch, and Facebook. These are by far the three largest platforms out of all the platforms that you could be streaming on. It doesn't mean they're the only ones. There's plenty of others, but these three I think are quite important for you to at least have a better understanding of. With regards to YouTube, what is the legal framework that you need to pay attention to? The terms of service and the community guidelines. Now, YouTube has a genius algorithm with which they scan all their content. And they scan it for infringements. And if it gets flagged, for instance, if I were to have this live streaming on YouTube and I were to play a song that is not licensed to me, it would flag it and suspend it. So the stream would be suspended. And if it didn't flag it during the live stream and a user flagged it later on, it may remove it from access. So what are tips here that you can be sure to protect your content and avoid it from being flagged or removed or suspended by YouTube? Now, YouTube has a very interesting way in which they deal with licensed content. You can get license granted by the owners of the content via their community guidelines, where you get added to their allow list. If you're added to their allow list, then you can play their content in your videos without fear of any infringement. YouTube ensures that you retain ownership rights of all of your content. However, it does grant specific rights to YouTube. Those rights being, and as you remember, these are bundled rights. So one of the parts of the bundle that they get granted has to do with access. So they allow your content to be accessed by other users, by other websites, and you also grant them the right to monetize your content. So they can put ads in and get revenue from the view count of your content. Twitch. Now, Twitch is a great one. I don't know if you're familiar with it. I am quite an avid gamer, and Twitch is just fantastic. You can just watch people play video games all day. But it's not just that, right? Twitch actually has more than 15 million unique daily visitors and 3 million content creators and broadcasters. 55% of Twitch users are between the age of 18 and 34. So if, for instance, your brand is seeking to engage with that segment of the audience, then Twitch could definitely be for you. But what is the legal framework here? Now, similar to YouTube, you're going to want to look at their terms of use and their community guidelines. One thing that I found quite particularly interesting with regards to that was their indemnities that they have. Now, they have a whole section with regards to endorsements and testimonials. And if you're not familiar with Twitch, this has to do with various users saying that this mouse is the best mouse or this keyboard is the best keyboard. And those endorsements therefore end up being part of the content that you put out there, and you have to indemnify them, thereby allowing Twitch to have any limited space of liability if, for instance, something goes wrong with what you've endorsed. Now, with regards to the license, remember I mentioned these three platforms structure it so that your content is licensed to them. Twitch, similar to YouTube, and you'll see Facebook, gets granted a worldwide license. Now, quite interestingly, they have a specific clause that deals with add-ons, maps, and mods. And this probably, most likely, has to deal with the fact that it's very video game centric. So when it comes to add-ons, maps, and mods, if, for instance, you remove your content, they will themselves terminate and remove any rights that they have to that submitted mod, map, or add-on. However, if you terminate your services with Twitch, and remove your videos, they still retain certain rights. And those rights aren't so that they can share those videos any longer on their platform. However, they still have access to the information contained in those videos and retain aspects of what you had previously granted them. Facebook. Now, you can't really talk about streaming or digital landscapes if you don't mention Facebook, right? Facebook is huge. The use of Facebook is far and wide, but specifically with regards to the live streaming, you need to look at the live policy. Now, they have a policy specifically geared towards digital live streaming. They also have a community guideline, and they also have music guidelines. The use of music for commercial or non-personal purposes, in particular, is prohibited unless you own or have obtained appropriate licenses. And even if you have the appropriate license, Facebook very clearly and expressly states that you may be region locked with regards to your ability to share that music or your ability to access that music. Now, Facebook Live must not be used to mislead its users. And that has to do with two specific things. It has to do with the time period that is being referred to. So you can't say that it's live and actually it's from a year ago. I remember particularly when there was quite a bit of storms in Cape Town. There were some videos circulating, and those videos were from over a year ago, and Facebook ended up having to flag them and get them removed. One thing that I think you must always remember with regards to these platforms is that you are responsible for the content that you post. It is not these platforms, and they ensure that you indemnify them in many regards and that their liability is limited in similarly. Sorry about that. So let's talk about these multiple jurisdictions. Specifically, I want to touch on three. That has to do with South Africa, that has to do with the United Kingdom, and that has to do with my homeland, US of A. So why is this important to understand? Well, the reality is there really isn't international copyright as we know other international laws. There are treaties, there are universal formalities that have been agreed upon between the signatories of those treaties. But insofar as international copyright, it does not exist. The protections that you get, the rights that you get are territorial. And the problem with that is that often, not always, but often, the infringements may be extraterritorial. Now, South Africa we'll discuss in further details just after this. But in brief, protections are based on categories. Generally speaking, the life of the author plus 50 years is the protection span given to the author in that regard. Now, the United Kingdom has a very different process. They give 70 years plus the life of the author. And for unknown authors, they give a straight 70 years. Now, the United States is even more complicated. They give the life of the author plus 70 years, but in some instances, they've given 95 years from, for instance, the date of publication. Copyright law is territorial and national in scope. Now, what this means is that when you change jurisdictions, the protections that you get, the rights that you get, will change with it. But what happens here in South Africa? So in South Africa, we have the Copyright Act. And the Copyright Act gives us very specific information with regards to how these rights arise and how the protections of these rights exist. What we do have is something called an automatic protection principle. Now, this is something that happens with regards to the Berne Union Treaty, which South Africa is included in. Now, authors are automatically entitled to protections against infringements of their work in foreign jurisdictions that are members of this treaty. South Africa is one of them. And in the South African jurisdiction, these protections will arise upon creation. The categories here we have are literary works, artistic works, computer programs, musical works, sound recordings, broadcasts, published editions, and program carrying signals. Now I want you to remember these categories because we're going to talk about them again later. But you can see that some of these will overlap. South Africa, so what my colleague and I were discussing earlier this week is that one of the interesting things about digital live streaming is where does it fall in these categories? Which category is it? Now you may want to say that it's a broadcasting category, right? It seems maybe that's appropriate, but the reality is the Copyright Act refers specifically to the Broadcasting Act. And insofar as the Broadcasting Act defines broadcasting, it has to do with the involvement of electromagnetic waves issued by a transmitter. Now, it seems to suggest that this definition isn't really sufficient insofar as digital live streaming happens. Digital live streaming happens via the internet, no more than data being shared and distributed. It's not broadcasting. It's not a broadcast in the definition given to us by the Broadcasting Act. Now, where does that leave us, right? Well, if you are a platform like YouTube, like Facebook, like Twitch, and you are broadcasting this content, perhaps then this area of the law would pertain to you. But if you're just digital live streaming, if you're just doing a webinar like I'm doing right now, it may be important to understand how these categories overlap into each other. So for instance, if you think of, let's go back just so that you can refer to them, films. So films will have literary work, they'll have musical work, both involved in the creation of the film itself. And it's important, if you remember those tips, to identify the creators, to understand who owns which rights, to understand if there's license that exists. If you don't do that, there's going to be consequences, right? And we mentioned this earlier on. It's important for us to understand what these consequences are, not necessarily to only deter us from infringing, but also to help us understand that when infringement happens, this is something we need to be ready for. Now, South Africa is quite kind when it comes to infringements. There's a fine of up to 5,000 Rand, imprisonment of up to 3 years. If you have a second conviction with regards to the infringement, fines can go up to 10,000 Rand and imprisonment may increase to 5 years. But unlike the United States, we don't have punitive damages. Similar to the United States, we do have interdicts. They just call them injunctions. These functions insofar as it prevents further infringement or prevents future infringement. Future infringement being the harder one to prove. Now let's talk about protecting these rights. How do you ensure that your IP, that your rights are not infringed upon? And this is kind of the practical takeaway for you, right? Well, unsurprisingly, as your legal advisor for this afternoon, I'm going to suggest that you ensure your contractual relationships are clear. Set out your intentions. Have the conversation. If it's appropriate, enter into some non-disclosure agreements where you're sharing your information only on the basis of a very specific purpose. One thing that has been very clear in preparing this presentation, it's that if you're looking to protect your rights, it may be in your best interest to create a brand. Build that brand, make it recognizable, and therefore proceed to create those protections regarding it. It may lead you to possible trademarks. One of the things that I keep saying is identify the creators, right? Here, we're talking about know who those players are. So if, for instance, you're including music, make sure that the person with which you're getting the license actually has the right to do so. You want these clear agreements to set out the expectations, to set out what the actual ownership rights are. For instance, it's very important to look at clauses that deal with license. For how long does this license exist? What permissions does this license give? You can tailor it to your needs. If you want to be conservative with how you grant those licenses, you can carve out very specific aspects of that right. If we think back to the way in which YouTube gets specific rights in their license, it's the right to monetize, it's the right to access. So what exactly ends up being the takeaway here? Well, there's a huge benefit, right, for you to participate in this social environment, right? You get to engage with your audience, you get to share your brand, but you have to do it knowing exactly which rights are involved, knowing possible pitfalls. I think it's very important for you to understand that the internet is a place where people can easily infringe on things that you put out there. So maybe before you even put anything out there, before you share your content, give it a thought. Which parts of this content are you willing to put out there? Maybe assess the risk. Now, I just want to see if any of you have some questions. I saw some popped up in the Q&A. Right, so can we elaborate on the licensing requirements of cover songs, i.e. a live stream and or video recording of an artist covering another artist's songs? Also, who would be expected to obtain the license? The performer or the platform production company? This is a really interesting one. I was speaking with my colleague this week actually about how, and this goes back to kind of that question of parody, critique, and reaction, right? We see a lot of these videos where it's people engaging with content, very outright engagement with that content. And they don't necessarily clearly have the right to do so, but they're not infringing directly. So I think one of the things that's really important is if, for instance, you are doing a cover of a song, insofar as it's part of your commercial intentions here, it would be very important for you to ensure that the license is held before doing so, right? But if, for instance, you're doing it to share your ability to sing and it's on YouTube, it's not likely to be an issue. It's not likely to be one where you've actually amounted to an infringement. I hope that answers your question. If you guys have any further questions, like I said in the beginning of this stream, I really am very happy to take any emails. You're very welcome to contact me and we can discuss it in further detail. I hope that what we've done today is kind of give you a little bit of guidance in how to navigate the tricky world that is the rights involved in your digital live streams, but also giving you kind of some confidence to participate in this. I think, you know, it's really important to understand that the internet gives us this ability to tap into communities. And we shouldn't be so afraid to participate and share, but we cannot do that without fully understanding what the consequences may be of sharing that. And with that, I'm going to leave you slightly chilly, but with a very warm heart, and thank you for participating in today's webinar. I hope to hear from you all with further questions, and hopefully see you at the next webinar series next month. Cheers, everyone.